Coming up on this program, we show you how to get connected, find out how to choose an internet service provider, discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello, bonjour. Hi, my friends. I hope everybody is doing well today. It's still really cold. I don't know what's going on with chat. My only theory is that chats don't move as fast as everybody thinks, and so freezing or like there's just not chat to be had. I don't know. What do I know? YouTube Daddy and I. Meh. Hi guys. Thank you so much for being here. I literally thought of something as we went live. I'm gonna eat my dinner or the rest of my food for today. Your chat is still freezing, Vicky. Shitty. Which is this cutie orange and a granola bar. And because I am an adult child, my juice box. Yes, that's right. And that will be that. Hi, runaway lions. I was just going over what I'm gonna eat for the rest of my eating time. It's fasting. I'm fasting again. So I have like, I don't know, an hour, less than an hour to eat. So let's get on it. What I was thinking about just as we were starting is that we didn't watch the first TPO. So why don't we watch that?
Seated, please.
Yes,
Good morning,
everyone,
everybody.
be seated, please. If you would, thank you, thank you, thank you. CYP's husband had a serious medical thing, and he is hopefully doing better, but really, really, really serious. Was in the ICU, and I think is at home now. Anyways, she needs our prayers, and that's why she's not been around. So, and I hope that if she needs, because she is popping in, I know he's home now. Is he home? Yeah, not good. Anyways, I'm sure her workload at home has gone up immensely. So do let us know, CYP, if there is anything we can help you with. Christopher Engleby, hello, my friend. So lovely to see your name. I'm eating. Please excuse me. I'm being so rude to eat my dinner in front of you, but I'm doing it. Where are we going? Who was it? Her? Him. Let's see.
Okay, and I think now I'm down to cases where there are two parties present, so we can go ahead with the hearings. As I described before, I'm going to start with Harmon versus Sprigg. So Mr. Sprigg, would you come up and have a seat? And
This is a
I've
paper
got
straw.
Rosalinda and Trevor Harmon on Zoom. This is case 24-371. Okay, so can I start by asking the Harmons, are you ready to proceed with your petition?
Yes, it's just me here today. Rosie was not able to make it.
Okay, and you're ready, Mr. Sprague?
Yes, sir.
Okay. All right, so the way we'll proceed is this. First of all, I'll swear the parties in, and then the petitioner will get to go first. In this case, that's you, Mr. Harmon. I'll hear your case first, so that means you can testify. You can draw my attention to any exhibits or material that have been filed in this case, or you can have anyone else who's a witness testify as well. Once I've heard your side of it, then I'll turn to Mr. Sprigg, and it'll be his turn to do the same thing. And then after I've heard from both sides, I'll make a decision as to whether or not there's going to be an anti-harassment order after today. It looks like there's already a temporary one. Now, during the time the other party is telling me about their case, I want to ask you to please just let them do it. Even if you hear them say things that you think aren't true, if you think they're, leaving stuff out or saying things that aren't true, just wait, because you either will have a turn to tell me your side of it in a few minutes, or if you've already told me your side of it, I already know that. So don't feel the need to interrupt anybody. Second of all, I might interrupt you to ask questions. I may need to do that so that I am sure that I understand what you're telling me. And then I may also ask questions just to kind of keep things on track to stay on the issues that are going to help me decide the case. Okay. When you're telling me your side of the case, keep in mind that everything that has been filed from your initial petition, any exhibits, any response to the petition, is already in the file, in writing. It's part of the record, and I've reviewed it. So it's not necessary for you to repeat orally things that have been filed in writing. Okay. You can, though, if you think you need to, draw my attention to certain sections of that you believe make your point. So, all right, with that, we're going to get started. Can I have both of you raise your right hands, please? Do you each swear that the testimony that you give in this case?
We swear that we don't care how much you interrupt us, Christopher. Thank you so much. You are amazing. Also, I just noticed that it says on the bottom here, Canada Choice. Do you guys not have this brand of applesauce? I know. I don't want to talk about it. Especially if it impacts my food costs, which are already high. Also, guys, this lady is from the crazy granny case that happened later in the day. Also, hi Presto. I know I look like an, I don't know. I'm not on my period. What was it, the other thing that you said? A funeral. And holiday blues. It is dark. But no, I've already done 10 kilometers or 15,000, almost 15,000 steps today. And I'm about to listen to these douches talk about this shit. Oh. And I honestly couldn't be bothered changing into something else.
This will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Yes.
All right, Mr. Harmon, go
Yeah.
ahead, sir.
So you have the declaration, you have the police
do.
report. The police recommended we do this. Basically, he threatened to kill me twice, and that's the main reason for the temporary order is you can't, take these threats lightly. So I think this is the best route. He lives at the end of the unit here. So currently in the process of gathering a lawsuit together to keep everybody from trespassing through my property. They believe they have some type of prescriptive easement, but there's nothing in writing, nothing documented to give them access to go through my property. They come through they must be upset that we're trying to gain the property back. So they come through with no remorse, trying to cause problems, and threaten to, like I said, threaten to kill me twice. So that's the main reason here.
Okay. Now I want you to do this. I want to focus on where you said threatened to kill you twice.
Yep.
Tell me, here's my question. Tell me, for both instances, when that occurred, and tell me what he said or did that made you believe that he threatened to kill you, and what your reaction was to that.
He said, I'm going to hang you. I'm going to kill you. You don't know who, what you're doing. That is exactly how it happened. Cops came the second time when we were there waiting for the cops after his buddies stopped and threw rocks all over my fence and ran up and down the road like crazy when we were having a birthday party out here. We followed them back at the end of the road where they went into, waiting for the cops to show up. He comes walking out and starts a fight with my 60-year-old father, pulls a knife on him, threatens to kill us. This is where we're at with it. So whatever's the best situation here, this is where we're at.
Okay. All right. Is there anything else that you think that I need to know before I hear from Mr. Sprigg and make a decision?
Either if you have any questions, let me know, but.
All right. Okay, Mr. Sprigg.
This all stems from the argument over the road that he's talking about. He has been harassing everybody who drives up and down that road, all the neighbors' guests. And it has gotten to a point to where people are afraid of him. The one, I did threaten his life one time while I was on the ground being assaulted by him and his father. I went out to tell them to leave the property again because in his report, it says 3 weeks earlier, but it was more around 2 months. He followed me and a friend of mine down the driveway to my house, threatening us.
After they drove by flipping us off.
Yeah, Mr. Harmon, remember what I said about interrupting?
Yeah, fair enough.
We did not flip him off. Me and my friend were having a conversation. We may have used some vulgar language, but it wasn't directed towards him. We didn't even know he was outside. He has a fence up. We can't see through it. We had no idea he was there.
Let's narrow this down a little bit. Okay, I want to know what this road, okay, the road that you're talking about. What kind of road is this?
It is a road that has been there since the 1930s. It does not have the express easement that we would request to have, but there is a type of easement. It is already in courts for that.
There's already a lawsuit about it. Is that what you're telling me?
Us down at the end of the community are getting a lawyer to pursue a case to get that easement.
All right. But this isn't a road like, a road like 36th Avenue or something.
No, sir. It is I guess a private driveway that he is right about the middle of it. And he wanted to close it all off to everybody so he could regain his property, because legally it is his property, but his property line goes to the fence. But the road has been there since the 30s. When he bought this property, it was already an existing road being used by everybody. It is the only means in and out.
So that's how you access your property then?
Yes, it's the only access we have.
Okay. And would it be fair to say then, based on what I've heard from both of you, that this road and access and use of it is kind of the source of conflict between you?
I don't have a conflict because I don't believe he's going to win. It's not my issue. I'm not the aggressor in this case. Nothing has happened at his house. He has cameras on his house, on his car, on his fence. If he had any evidence, where is it? The fight that he's talking about happened in front of his Tesla. It has cameras. If he wanted to produce that evidence to show exactly what happened, where is that? Him and his father came down and assaulted me when I told them to leave because they were harassing a friend of mine. I don't have cameras at my house. Otherwise, I would produce that evidence.
I understand what you mean. And I just wanted to clarify that point about the road that you both referred to. Okay. All right, and then I'm going to turn back to you, Mr. Harmon, and ask you kind of the same question, because I asked that question of Mr. Sprigg.
Yeah.
Describe for me this road that
So it's not a road, it's my property that folks have been trespassing on for quite some time. The lady that owned the property before me won a lawsuit against it. My surveyor just provided me with all the documentation showing that nobody has an actual prescribed easement or any type of easement to come through my property. Not only is it my property, it's the next 4 houses up. So they're trespassing through 4 parcels that they're not supposed to. They all have private easements to go out the other side. They just don't want to develop it, even though it would just take, couple couple trees taken out and a little bit of rock on the road, and they'd have access or a way to go out.
Okay, so it does sound to me, based on your answer as well, that this issue is the source.
It's not the source. What happened is that the real reason why and I haven't harassed anybody going through there. The neighbors are actually coming down and talking to me, telling me that Mr. Spriggs is trying to give them lied declarations to submit to you guys, and that they wouldn't because they have their own conflicts with him. But that's besides the point. Him and his buddies drive through here because they're upset about the road. So they drive through like idiots. They flip me off, yelling cuss words, creating conflict. We're out here with a 9-year-old girl's birthday party with a bunch of kids running around, and they're stopping at the front driveway, kicking rocks, pilling out. Enough's enough. We follow them to find out who it is. They drive like crazy, flying around, won't stop, won't let us address who they are. They go back to the end of the road, and we call the cops. He walks up to our vehicle and pulls a knife out, saying that we harassed him. And if I had Tesla video, we would produce it. There's no cameras on the Tesla.
So let me ask you this question then. What is it that you want the court to order him to do or not do?
There should be a protection order from him to be walking up to me. I don't even want them to come through my property. So I'm working on that. They have another way out. So I'm working on the lawsuit for them not to be able to come through here. Right now, I'm told I can block it all off as well as all the other neighbors. So that's
let me just hold on there with in this case, this lawsuit that you're in front of the court for right now.
Yeah.
What is it that you want me to order Mr. Sprigg to do or not?
I want a protection order against him not to come near me because it's going to be a problem. He's threatening to kill me. Isn't that obvious enough? He even admitted, I better not come near him. I'm threatening to kill him. He's an belligerent drunk on the weekends. He can't even stand straight, and he's sitting there acting as if he can remember the story.
All right, that answers my question, Mr. Harmon. Thank you. Okay. All right, Mr. Sprigg, I kind of cut you off there. Did you have any other evidence you wanted to present?
Nothing other than the declarations that you've already read as to how he is the one being the aggressor.
I have read the declarations.
I have done nothing. He has nothing on camera, with cameras all over everything he has. Teslas do have cameras. They record sides, front, back, everything.
I don't.
Nothing has happened at his house. I've done nothing.
All right. I want to clarify too that you talked about a potential lawsuit, but I don't see a record here that there is anything filed yet.
No, there is not. I have not.
It's something you're contemplating.
I'm thinking about, yes, I want to get a personal injury attorney because I'm going to have surgery on my shoulder from the assault from him and his father.
Right, I got it. I understand. Okay.
Yeah, there's definitely going to be a lawsuit for the injuries.
I've got real conflicting statements here about what's going on, about who may be the aggressor and who may be the victim of aggression. There's active denials by both of you that you did anything to aggress against the other party or to threaten or to hurt anybody.
He admitted that he threatened to kill me.
So
he's threatened me as well.
Yeah. Okay. I've heard from you. Okay. I'm gonna make a decision here as to where we're gonna go from here.
Okay.
All right. Now, I want to make sure that you both understand that this court can't issue any orders on this property, this road that you both talked about. Whether it's an easement, whether it's not an easement, whether you have a right to be on it or you don't, to use it or not, who owns title, who may have a prescriptive easement or any other form of easement. Can't rule on that. It's beyond the jurisdiction of the court. So I'm not going to make a ruling on it. That's going to be up to you to resolve in the correct court, which would be in Superior Court, a quiet title action or something like that. Don't know. Maybe there's an easement there. Maybe there's not. You know, you'll get that sorted out in the proper way. Now, as far as conflicts that, you know, are personal in nature, not over pieces of property, about threats, about weapons being brandished, police being called, physical altercations, that's the kind of stuff that can constitute harassment. And it doesn't matter if the impetus for it is this conflict over the road. It doesn't really matter what the impetus for it is. It's not proper to use, you know, physical violence and threats of violence to get your way or to get the other party to back down or to, you know, you can't solve your disputes like that. And if these things are going to come to blows or to knives being produced or anything like that, that's obviously something that we have to be concerned about. Now, I have to be able to find, by a preponderance of the evidence, which means, Mr. Harmon, the burden of proof is on you to show by a preponderance of the evidence, the greater weight of the evidence, that Mr. Sprigg is engaged in harassment. And listening to you both here, I'm going to say, I don't believe that burden has been met. Mr. Sprigg, Mr. Harmon, you're both, as far as I can tell, listening to what you have to say, reading what's been submitted on your behalf, you seem about equally credible to me. And you seem to have, you know, equal passion about the other guy being wrong. But at this point, I don't have sufficient evidence.
Did you read the police report?
Yeah, Mr. Harmon, let me explain.
More passion, more energy, more footwork. Yes, we do, Lucy, but we did last month. Celebrate Thanksgiving. We do it ahead of you guys. I don't know. We've talked about it. Although I think that the trickle-down effect still exists here. I think they start selling turkeys in October here and then all the way through to Christmas, basically. Turkeys and all the like. We don't really do green bean casserole, which I've heard a lot about. Some people loving, some people hating. But stuffing or dressing, mashed potatoes, candied yams, or like that dish is. Yeah. We do. We do indeed. Anyways, after this case is done, I'll pull up one more case from Judge Kirkham, and that will be that.
Something to you. I listened to you. I read your evidence. I listened to Mr. Sprigg and what he had to say about it, and I'm making a decision. It is not appropriate to continue to argue with me. I am going to write this decision down on a piece of paper, and that is the final order of the court. If you're not willing to listen to any of the reasons for it, I won't issue any further reasons. I'll just write it down, and you can have a copy of this when we're done. But it will do you no good to argue and yell at me after I've heard your evidence and made a decision.
I just asked if you read the police report.
I told you I read everything.
So good to sign off? Nothing else needed?
Sign off if you'd like to.
Peace, he says. He just left. He just left, ladies and gentlemen. He just fucking left. I mean, I sort of get it. A little bit. Anyways, let us go to Judge Kirkham's court. We already listened to that part. Now we're over here.
I'm trying to get the video. There it goes.
Ma'am?
Okay.
Ma'am! Just wait until I'm fucking done. Thank you.
Present.
Hello?
Hello.
I'm trying to get the video. There it goes. Okay.
All right, calling case 2009-4118 DP Miranda Finley versus Avery Miller. Today is Monday, November 25th, 2000.
Do. Christopher Engleby, that dude was a bit disgruntled, eh? He was like, that's my road, and they've been using it and thinking it's their road forever. Judge Kirkham is handsome up close. He looks good for his age. Whatever that age may be, he looks good for it. Thank you again, Christopher. Carol, you may have seen it earlier because it happened yesterday. Oh, the cringy court caller. Yeah. Sometimes she comes through clear. It's usually when he's here. Oh my god, I've been duping you all. Would it surprise anybody to know that Judge Kirkham is in fact an AI judge that I made in an AI program? And I upload every day. Christopher, love you too. Thank you so much. Have a great night. You made me want crumble cookies, sir. All right, here we go.
924 at 10:40 a.m.
Court will note that this matter is before the court on the defendant's emergency motion for an ex parte custody order. In this matter, ma'am, you've alleged a number of things as far as some pending parental kidnapping charges, et cetera, but you've not alleged what happened as a result of those charges. Have the charges concluded in any way?
I haven't heard anything, no.
Okay. Go ahead with your motion. Anything else?
This wasn't my motion. This was his motion.
Okay, I did say it was defendant's motion. I'm sorry, ma'am.
It's okay.
Mr. Miller, go ahead with your motion.
Okay, Your Honor, my name is Avery Miller Graham. I'm the father of Alea, Amira, and Akira Miller Graham, the minor children involved in this matter. I'm appearing before the court today in ex parte proceeding to seek immediate relief due to Miranda Finley violating the current parenting time order and engaging in abusive conduct towards our middle child, Amira Miller Graham. I respectfully request that the court issue temporary relief to protect the minor children's safety and to enforce my parenting time rights. The court has jurisdiction over this matter pursuant to MCL 722.27, which governs custody and parenting time in Michigan, and the venue is proper as Calhoun County is where the minor children reside. The parties were previously ordered to follow a parenting time schedule established by the court. However, Miranda has violated this order repeatedly by withholding my parenting time, thinking she is above the court, picking and choosing when I can see my children, and not allowing me to see my children on my weekends or any weekend at all. In addition to violation of the parenting time order, I have serious concerns regarding the safety and well-being of my daughters. Miranda Finley has engaged in abusive conduct towards Amira Miller Graham, including choking, fighting, bullying, taking verbal abuse, taking minor child's phone so she can't call for help. As a result of this abuse, my children
do not wish to continue to live with Miranda Finley are constantly depressed, scared, out of fear of Miss Finley. There's also an ongoing CPS case with Miranda. She hasn't been taking the youngest child, Akira Milligram, to school because Miranda was banned from Akira's school due to hysterical, vicious behavior on 4 separate occasions. I request for temporary relief from the court on an emergency basis in order to prevent further harm to the minor children and to enforce parenting time rights. An order requiring Miranda Finley to immediately comply with the parenting time schedule as set forth by the court, temporary custody of the minor child, or at a minimum supervised parenting time until further proceedings can be scheduled. An order directing Miranda Finley to immediately return the minor child's phone, as it is a reasonable expectation for the child to have access to communication with both parents. A temporary protection order to ensure the safety of the minor child if necessary. An order directing Child Protective Services to immediately investigate these allegations of abuse and file a report with the court.
Okay, anything else, sir?
No, that's it.
Okay, well, I will tell you, if CPS if there's a basis, they will investigate and then they will file a report at the conclusion, basically, of 30 days. So that's if they find that there's any basis for that. So I don't need to order them to do something that they're required to do in any event. What happens is the court will enforce the orders of the court. So if you're not getting parenting time, then the court will enforce that, and that parenting time will be ordered. If a party doesn't comply, they risk going to jail if they don't comply with parenting time. Ma'am, anything else you'd like to say before we conclude?
Yes, sir. So, Avery Miller has brainwashed my 14-year-old into believing that she's not safe. Her phone got took due to her failing grades, not because of her safety. I had recently moved back to Calhoun County, and my kids were going to Lakeview School, but I pulled them out of Lakeview School due to Avery going up there with CPS and acting like he was CPS and interrogating my 10-year-old daughter without my permission regarding that he has no parenting time, he's not on the birth certificate, and he's not on any paperwork. So I'm in the process of transferring their schools due to the safety of their concern, my concern for my kids, because he wasn't even supposed to know where my kids went to school at, because since he literally did this as soon as I moved back down here. He has not tried to get my kids since we went to court. He was able to talk to my girls on their own phones whenever he wanted to. He's been riding past my grandma's house harassing me. I just got this court order, so I haven't been able to go down to the courts to file a protection order against him, because I have text messages and everything that I need to send to the court of him threatening me, him calling, like, it's always this. He's always threatening me. He's harassing me. I let him get his kids when he wants to. I let his family get the kids when they want to, until it comes to this. He literally went to my daughter's school and interrogated her, and the school thought that he worked with CPS. So I had an issue with the principal about it, and they put a no trespassing on me because I went up to the school because he pretended that he worked with CPS.
Okay, well, ma'am, you say that he has nothing in this matter that gives him any rights, but the court does note that there was an order for custody and parenting time back on March 22nd or 21st, 2022. So how are you saying that there's no paperwork?
His parenting time was taken because of that.
Taken?
Yes.
Okay.
Your Honor, can I say something?
Go ahead, sir.
I never posed as a CPS worker. I had to meet the CPS worker, Nikki Booker, that was on the case. I had to meet her at the school because of several failed attempts to meet with Miranda to interrogate, as she calls it, the kids, the minor children. She was dodging Nikki Booker, so I said that I would meet her at the school. Nikki showed them her credentials and everything. I can't pose as a CPS worker and not show them any credentials, and they let me talk to a minor child.
Okay.
And she's right as far as that goes. Like, I'm not able to get any records from the school because the records would indicate that Akira has only been in school maybe 2 weeks, and the school year started months ago.
Because she was going to Lansing School before we moved down here.
Okay, let me see.
Can I say something else as well before you're done?
Just a minute, ma'am.
I don't understand why we got to keep going through this and our kids is.
Ma'am, just a minute. Okay, I wanted to get back to the order, so I'm pulling the order up. Okay, this is the order that was dated March 21, 2022. It did provide for a suspension of parenting time pending those parental kidnapping charges. And you're saying they haven't been resolved at this point?
No.
Your Honor, they have been resolved. They lessened the charge because it was never me just like taking or kidnapping the kids. It was me not sending them back to the mom on as the court order stated. I was supposed to send them back, and I never sent them back. So that was violating the court order, and it started out a parental kidnapping, but they lessened the charge, and I ended up getting probation and did probation for it.
Okay. Well,
In Kalamazoo County.
what you're going to have to do, sir, is that order is still in place until it's changed. So as it relates to parenting time, you're going to have to file a motion for parenting time in this matter, and you're going to have to set forth the basis for doing it. And then the court will entertain it at that point, but this is a different motion. You're seeking a motion for ex parte custody. Custody is different than parenting time. Anything else, ma'am, before we conclude?
Yes, two things. The CPS case was closed due to no findings, and I wasn't dodging the CPS worker. I got in touch with her, and I also have text messages proving that I was trying to get in touch with her several times, and she canceled on me several times.
Okay. Well, what the court notes in this matter is that the defendant does file the motion in very conclusory terms. There's no allegations of fact on which the court can determine if there is in fact probable cause or change in circumstances sufficient to modify custody. And the request is for modification of custody. And as a result, there's no basis for the court to do that. So I'm going to deny the motion at this time. Ma'am, you're going to have to prepare an order denying the motion. And otherwise, sir, if you wish to have parenting time, you'll have to file a motion for that and set forth facts on which the court should base the finding. So court will conclude this matter. You're free to go. Have a good day.
Thank you.
Oh, so he filed a motion, but it was the wrong motion. Oh, so close yet so far. And then a few courts in session tomorrow, many are off all week. Yeah, I am getting that vibe. I was busy today, so I was not at my computadora able to record Braunlick this morning, but I did see that I should have, but I didn't. Let's continue a little bit longer. That's what she said. I'll eat my orange and pretend it's like a dessert. Oh, also, yes, these are crispy fried onions. I got them at the dollar store, Dollarama. They're $1.75, and I love them. I should not eat them out of the container like that. But my dinner, I guess. That's all we're getting.
We have Eli Foster. We do not have plaintiff Chelsea Foster in our. Please unmute. Calling case 2024-2701 DM Chelsea Foster versus Eli Foster. Today is Monday, November 25th, 2024 at 10:52 a.m.
This matter is before the court on the defendant's motion to determine child born out of wedlock in this particular case. Sir, what we're going to need in this matter is you've not done genetic testing, is that correct?
Yes, Your Honor.
Okay. What the court will do is the court will order genetic testing between you and the child. And then once we have that testing back, then the court will schedule an evidentiary hearing where we'll take some testimony. Those hearings don't take long. They take maybe 15 minutes to, somewhere in that 15 to 20 minutes. But we're going to need, because there's nothing else in the motion for the court to base it on, the court's going to have to order the genetic testing. That testing will have to be done by a certified lab as well. Sometimes people will want to get those tests done through some kind of a home, genetic testing. Those won't satisfy the evidentiary requirements, so you'll have to go through a lab. If is the child on any public assistance at all? Do you know?
I have no idea, Your Honor.
Okay. What you can do is contact the friend of the court's office, call them and speak to Attorney Magnuson. If the matter qualifies as a 4D case, then you'll be able to get the DNA testing through him, and it's far less expensive than what you'd have to do it independently.
Okay.
Okay. So contact his office, set up that. Once we have the test results in, the court will set a hearing.
Okay, Your Honor.
Okay. Okay. Thank you, sir. You have a good day.
You as well, Your Honor.
Court case, I do not have Ramon Guerrero or Jerry Diaz in our waiting room, so we'll call the business court case and then.
Well, call this one. It's enough time. We'll call it and then just we'll put it over, and then you'll have to renotice it if she wants.
Calling case 2022-2792 DM Ramon Guerrero versus Jerry Diaz. Today is Monday, November 25th, 2024 at 10:55 a.m.
Court will note in this matter, it is now 10:55 a.m. The matter was set for 10:30. In this matter, neither the plaintiff nor the defendant have appeared. The matter is before the court on the defendant's motion to set aside order of affiliation and to revoke affidavit of parentage or acknowledgement of parentage in this particular matter. As the parties are not here, the court cannot proceed. And as a result, the court will not proceed in this matter. If the defendant wishes to proceed, then she'll have to renotice this matter for hearing.
Okay, Judge. I'm just entering all my calories I just ate. That orange was fucking delicious, by the way.
Not proceed in this matter if the defendant wishes to. Hold on, we've got to delete the file, renotice this matter for hearing.
Calling case 2024-2382 CB HMFM Holdings LLC versus Orphan Education LLC et al. Today is Monday, November 25th, 2024 at 10:56 a.m.
Court will note the appearance of Ms. Nazel and you got to delete the file, renotice. Hold on, it's our setup. They've got to delete the Do you have that done now so we don't get the feedback?
I'm not sure. I think the feedback may be coming from someone. Are we good now?
Yeah. Court will note, as I stated, that Ms. Nazel, you're on behalf of the plaintiffs, correct?
That is correct, Your Honor.
Okay, and then we have Mr. Monroe, you're on behalf of who?
Tarek Muslim.
Okay,
And Your Honor, this is Dave from. I'm on behalf of Orphans Education and Haitham Masri.
okay. I had a Attorney Miller, I think, previously in there. Are they in your office?
He's not in my office, but he is co-counsel.
Okay, got it. Okay. This matter is before the court as stated on the plaintiff's motion for a temporary restraining order and or preliminary injunction. Ms. Nazel, you can proceed.
Thank you, Your Honor. As you stated, this is our motion for a preliminary injunction and a quiet title action with respect to property located on 1007 Industrial Avenue, Albion, Michigan, which is currently being operated as a cannabis grow and harvesting facility. Your Honor, my client has invested $700,000 in reliance representations by the defendants that HMFM Holdings is the rightful owner of the subject property. And given the clear risk of the property and the business operation, the employees, we respectfully request that the court grant our preliminary injunction to preserve the status quo of the business and property until the resolution of the proceedings. Your Honor, I lay out my argument in the motion. I believe the court has already reviewed our motion, hence why they already entered the temporary restraining order. But I would like to just highlight a few facts with respect to the four elements that the court considers to issue a preliminary injunction. With respect to irreparable harm, Your Honor, Michigan courts have long recognized that the potential disposition of real property does constitute as irreparable harm, given that it's a special, it's significant. With respect to this case, Your Honor, the risk is compounded by the ongoing operations of a business, which requires stability to remain compliant with state regulations. If the property and or business operations are disrupted in any way, my client, as well as Mr. Muslim, stand to lose a substantial amount of investments that have gone into the viability of the business. And there's no adequate remedy at law because monetary damages are cannot preserve the real property. The defendants won't suffer any prejudice in with respect to a preliminary injunction, maintaining the status quo until the resolution of the case, Your Honor. Muslim, who's a defendant in this case, is a 30% member of HMFM Holdings. He only benefits from the success of the business. And Orphans Education and Mr. Musri have previously agreed to a stipulated order, which demonstrates their cooperation to a resolution. I have attached as Exhibit H the email exchange between me and Mr. Stockram. With respect to public interest, this does serve the public interest of the community. The business employs over 20 staff members who rely on the income that they receive from their work at this business operation and their livelihood, plus the stability of the business ensures compliance with Michigan's cannabis regulations, which is a broader interest of the state and community. The final element, Your Honor, with respect to likelihood of success on the merits, I have attached most of the record that I have in my possession when it came down to this transaction. The evidence strongly supports our claim. I've attached an email as Exhibit F from Eric Norden, who represented the defendants prior to my client's involvement, establishing the chain of title. Specifically in that email, it shows that HMFM Holdings is the last title holder and makes no reference to any other interests, specifically Orphans Education or Alethea Realty. Subsequent documents that were exchanged between the parties, I've attached as Exhibit K and L. The management service agreement as well as a security agreement establish that HMFM Holdings is the real property owner. With respect to Alethea Realty, who issued a notice to quit upon my client about a month ago. There's an email that was provided by Mr. Stockram from Mr. Norden suggesting that Alethea Realty had relinquished its interest in the property. I don't have the executed documents, Your Honor. We haven't commenced discovery, but I do intend to subpoena Mr. Norden for the entire file during the pendency of this case. We have one party who had agreed. We have three parties, Your Honor, who are contesting the title of the property. Orphans Education and Mustery are saying they're the rightful owners. My client, HMFM Holdings, is arguing that they're the rightful owners, and then Alethea Realty, based on their notice to quit, are now stating that they're the landlord. So there are three parties who would benefit from this TRO. Mr. Muslim, who is a member of HMFM Holdings, who is the only party who was opposing the TRO, would also benefit from this because he is a member who benefits from the profits of the business. So at this time, Your Honor, I'm asking the court convert the temporary restraining order into a preliminary injunction for the pendency of this case.
Okay. Why don't we go with you, Mr. Monroe, first? You had agreed to a temporary restraining order, so I take it you don't oppose the preliminary injunction at this time.
I never agreed to a temporary restraining order.
Oh,
It was Mr. Stockram, Your Honor, Dan Stockram.
okay. I'm
Your
sorry.
Your Honor, I did not agree to. We agreed to provide an order. That order was circulated. It was never signed. And when Mr. Monroe began representing, we had a discussion, and that order was never entered or agreed to.
Okay, well, good. You clarified. I guess that's contrary to what the plaintiff had alleged.
That's true.
Mr. Monroe, go ahead.
Well, there are a few things that I think that I need to bring to the court's attention, but let me start off with what counsel for the plaintiff is not telling you, either because she doesn't know or because she's just not doing it. March 30th of 2022, there was a land contract executed between HMFM LLC as seller and Alethea Realty LLC as buyer. So the equitable title of the property, and just so that the record's clear, when I refer to the property, I'm talking about the industrial property known as 1007 Industrial Boulevard. The equitable title was transferred to Alethea Realty under the land contract. On September 18, 2023, the seller, HMFM LLC, made an assignment of land contract interest between itself and transferred that to Orphans Education LLC. So that at that moment, HMFM LLC had neither the legal ownership nor the equitable ownership. It still was listed as the record owner with the Register of Deeds, but it had no interest in the real estate, having assigned its vendor's interest and had already sold the vendee's interest. So on March 14, 2024, Mr. Eric Norden, an attorney, sent an email with documents explaining this and giving Mr. I can't pronounce his last name. He goes by Mo, but the plaintiff, explaining to the plaintiff through these documents the status of ownership, the fact that there was a land contract between HMFM and Alethea, and that HMFM was not the owner of, or that it had already assigned the seller's interest in the land contract. So that excuse me. So none of this is in the complaint. None of it is in the before the court, either in the amended complaint, the original complaint, or in plaintiff's motion. I called Chambers last week to see whether or not you would today take witnesses or exhibits, and I was told that typically you would schedule an evidentiary hearing at some time in the future if you thought it was necessary. So what plaintiff is attempting to do is to say that HMFM LLC owns the property when it doesn't, and that Alethea Realty has no right to obtain possession or rent, which it does because it is the equitable owner of the property. And there are documents that we can introduce. There are witnesses that will bring those documents into the court. And this will defeat both the complaint, the amended complaint, and this TRO. So there are a couple of other things I'd like to bring to the court's attention. The TRO, neither I nor Dan were given any notice or given copies of the TRO motion or the proposed restraining order. What we got was an email that said attached are these documents, but they were not attached. And we did not get copies of the documents, the TRO motion or the order, until after the court entered it. Michigan Court Rule 3.310 says that, by affidavit, plaintiff has to show why notice wasn't given to us and why we were not permitted to be heard by the court in opposition of the entry of the TRO. The other issue is that this is property that is valuable, that the plaintiff, Mo, had agreed to pay $25,000 a month to possess. And we've got that, and he's not paying anything, which is why I sent a termination notice that would be heard in the district court to terminate tenancy for failure. Well, I did the 30-day notice, but he hasn't been paying any rent. The business is not paying any rent. And there's an agreement that it was going to be $25,000 a month. No, that's nowhere in the complaint, the amended complaint, or in the pleadings to get this TRO. I want to speak for a moment about the amended complaint. The amended complaint was filed on the 15th, and it was filed without permission of the court. No motion, no order of the court permitted this filing. The defendants had filed an answer, and if you go 14 days from the date of that answer, the plaintiff could file an amended complaint within or on or before the 11th of the month. The 11th was Veterans Day, so they had until the 12th. It wasn't filed until the 15th. So I don't know. I mean, there is no amended complaint. It was improperly filed. Plaintiff got the court to issue a summons, which is in violation of law. So, I mean, that's a problem. I would request an evidentiary hearing so that the court can be fully informed, have time to review the documents. I don't believe that Alethea was served. Alethea Realty was served. They're a critical party. But I also don't believe that they're a party to the lawsuit because they were added in the amended complaint, which was improperly filed with the court, and the summons is illegal.
Okay, thank you. Mr. Stockram, what's your position?
Your Honor, just a very brief background on what's really going on here. This was a transaction that was handled by one attorney for both sides. The fraud that is being suggested here was documents that were given to both parties that evidence that there was going to be a transaction wherein the real estate owner would collect rent or get land contract payments, and that the plaintiff would be operating a cannabis facility on that property. The only document that got signed out of all the documents, that attorney that was representing both parties, was the operating agreement that supposedly gave the plaintiff a 70% interest. Now, were a number of documents, guarantees, amendment to land contract, all of the documents that were being suggested in the pleadings that the plaintiff was not aware of were either drafted by or given to him by his attorney, that he now suggests he was defrauded. But the whole reason that you're here, Your Honor, is very simple. They agreed to allow him to install his equipment and begin operations prior to the actual license being issued. The whole purpose of him delaying on the document signing was supposedly because he wanted to make sure the license was issued. Once the license was issued, the only document that he recognized and the only document in these pleadings that plaintiff decided to tell you about is the operating agreement that said he now has 70% of the ownership. If you believe what's going on here, you would believe that he is now 70% owner of a property that's potentially worth $1 million without paying a dime. That the defendants basically gave him the property so he could go operate his own business in that property. The reason we're here, Your Honor, is because he's now operating it. It's generating every 2 to 3 weeks $150,000 to $200,000 worth of cannabis. The purpose of this restraining order and the purpose of continuing the injunction is only to make sure that he continues to operate this property and take the revenues from this property, none of which have been paid neither to the minority member of that operating agreement or to the plaintiff that owned the property. So right now, they're asking you to continue the delay and enjoin a district court that has jurisdiction over a matter like this, just so that they continue to operate as long as possible to take as much money and cannabis from that property as possible until supposedly a resolution, which, given the number of documents, and you can see there's a number of documents to review, there's different things. But, Your Honor, they're basically telling this court that we filed this in good faith when, in actuality, this is a delay tactic. They demanded mediation from the other defendant. They've requested that I consent to mediation. And the only purpose that you're here is to make sure this goes on as long as possible. And while my client gets no payment on the lease, no payment on a land contract, no payment whatsoever for the property that is worth $1 million that he is now operating in. That's why we're here. We're not here because there's a number of technical things that we have to talk about or procedural things. They're asking you to help them delay this for as long as possible so that they have enough money out of this at the time so that the longer it goes, the more money they get. And they are not paying one dime to anybody, and they're occupying the defendant's property. So the idea that this is some benefit to all the parties is just simply not true. My client is getting absolutely nothing for their $1 million investment while they're in the property operating. And the attorney that handled this transaction, just as a slight bit of background, was representing both parties. And the moment that the plaintiff signed off on that one agreement, even though he had a half a dozen agreements with it that were supposed to be signed to structure this transaction, only signed the one that puts this in front of you that says he's 70% owner. That's the fraud that we're talking about. We're not talking about any other fraud. All of the documents that are suggested here that supposedly were done in fraud were all documents he was aware of and knew about. So granting a TRO only serves to disadvantage my client, to financially burden him further, and to extend this and give leverage, which is what this is for, is to give leverage to the plaintiff so that we will be required to grant him a settlement. He did put equipment in that property under the agreement that he was supposed to sign, that he never signed other than the one document that gave him a legal advantage. So at this point, he's not the owner, but he is occupying, but he's not leasing. I don't know of any transaction whatsoever that is handled this way where the parties in there has been in there since, and they're asking for an emergency TRO from you when they've been in that property since July. Only at this moment do they say, hey, wait a minute, we need a TRO, when they've already been in there operating for months. So there is no emergency here, Your Honor. This is just a matter of they do not want this litigated anytime soon. So as long as they're receiving their money, and they provide no accounting, they've given no money to the minority operating agreement member. They've given no money to the person that owned the property. The only thing they've done is grow marijuana, distribute it, and take the funds. And that's what's happening every week to the tune of $150,000 to $200,000 in revenues. So in making your decision, Your Honor, if you decide that this order needs to go forward, then at least grant the defendants an accounting for what they've been doing, because there has been not one single piece of paper to say what they've been making, how much they've been making, what share would go to the other defendant, or what would ever be going to my client. They're posturing that my client that owned this and owns it now is not entitled to any money whatsoever and will never get any money. So extending this does no purpose whatsoever other than to delay your court from making a decision on this matter. That is not something that doesn't prejudice my client.
Your Honor, may I?
Yep, go ahead.
I'm first going to,
Let me ask you first on this.
Yes.
Mr. Monroe stated that there was a land contract back in 2022, and then the assignment of the land contract in 2023. Do you acknowledge that or not?
No, Your Honor, we don't acknowledge that. We acknowledge that I received documents with the land contract and assignment, but we question the validity of those documents given the email correspondence. The issue is, Your Honor, if I may, with respect to Mr. Monroe's allegations, first, I would like to address his allegations with respect to my improper filing of the amended complaint and summons.
I don't need to address that. Address
Okay.
the substance of the argument.
Thank you, Your Honor. Just given that there's no motion to strike. With respect to Mr. Monroe's argument that there's a land contract, we're questioning the validity of that land contract. We received a plethora of transactional documents and email correspondence from Mr. Stockram after the filing of this lawsuit. A review of those documents established that certain documents were not created until August of 2024. When I asked Mr. Stockram, when were these documents created? He had indicated, well, they were executed in May of 2022, and he sent me an email saying, here's the evidence to establish that there's a land contract. Okay, if we take that as truth, then why did you not represent to my client that there's an equitable interest of Alethea Realty, and the ownership interest is now assigned to Orphans Education? Why did you send my client a chain of title without mentioning any of their interests? And Mr. Muslim and Mr. Mosley were both copied to the emails that Mr. Norden would send Mr. Khatib. Mr. Monroe now says that there's this email where, or Eric Norden, their prior attorney, had mentioned all of this. Your Honor, I'm looking at the email. He doesn't mention any of this. The very email that Mr. Monroe is alluding to. He talks about about 1007 Management LLC, which is not a party in this case. In fact, he mentions that Alethea Realty relinquished its rights to the land contract. I don't have the executed document. We need some discovery on that, but we don't believe Alethea Realty ever had an interest. In fact, the only time we found out that Alethea Realty existed is is when we received the notice to quit after the filing of this lawsuit. So when we dug in further and we reviewed the emails, there's an email from the attorney saying, here is a document relinquishing the rights of Alethea Realty. Your Honor, then I called the Cannabis Regulatory Affairs and I FOIA'd certain documents. The documents that the defendant submitted to the state prior to my client's involvement state that HMFM Holdings is the real property owner. So who are the defendants defrauding? My client or the state or their attorney? I have no idea. But with respect to another allegation, there's a lease agreement. I was never provided a lease agreement stating that there's a $25,000 payment to be owed to Alethea or Orphans Education. They're both mentioning a lease agreement. So I don't know who the lease agreement is for. Mr. Stockram just said he hasn't paid lease. Is it Orphans Education that gets the lease, or is it Alethea Realty now gets the lease payments? But I've never been provided a document to establish the lease terms or the lease payments. With respect to financial harm, Your Honor, I will agree with this court. I will stipulate that we will provide an accounting per our prior stipulated order with respect to any money derived out of this business. And I told Mr. Stockram we'll agree to this, but I'm not entirely sure why Dr. Musri is requiring the accounting. He has nothing to do with HMFM Holdings. I will provide the accounting to the members, and that's Mr. Mazloom. So I will stipulate that if this court grants our request for a preliminary injunction, then my HMFM Holdings will provide an accounting to the parties on a monthly basis with respect to any sales of, with respect to anything going on with the business, as Mr. Mazloom is entitled to. We never rejected that request. They indicated that we're trying to delay the court from both parties, which is prejudicial to them. Your Honor, I did not file an ex parte motion when we filed this lawsuit. Initially, we were working good faith, as evidenced in the emails that I've provided to you between me and Mr. Stockram. Although we didn't agree to a final order, Mr. Stockram and I were entertaining a stipulated order to maintain status quo in order for us to mediate. It's not only Mr. Monroe, when Mr. Monroe joined in and representing Mazloom, who's a 30% member, who opposed it. If the court would like further, in addition to an accounting, we will preserve any profits made out of the business in order for Mr. Mazloom to feel some security. But he hasn't demanded any records. He's cut off communication with Mr. Khatib completely. At this point, I don't believe it's a delay. I believe it's peace of mind for all parties in order to litigate this issue. It is a complex transaction. A lot of documents were exchanged. All three attorneys that appear before this court were not part of those transactions. Eric Norden's testimony, as well as subpoena of documents, is necessary for us to discover and litigate the issues at hand.
Happy Thanksgiving, MPC. That's so sweet. Thank you. That's so sweet. Thank you so much.
Okay, thank you. Mr. Monroe, your response.
Plaintiff's counsel is saying that she has a copy of the email that I'm referring to from Eric Norden. If it is the March 14th, 2024 email from Eric Norden to her client and to my client, it attached 4 documents. And one of those documents was entitled Superseding Amendment to Land Contract. And the first paragraph says, this superseding amendment to land contract supersedes and replaces the land contract between HMFM Holdings and Alethea Realty effective March 2, 2022. So when counsel says that she was unaware of any land contract with Alethea, or that she didn't know anything about Alethea before the notice to quit was served on her client, she admits that she has a copy of this lawsuit. She's actually attached a couple of documents that were attached to this land contract to her motion, to her TRO motion. And I'm sure that she has this superseding amendment to land contract. While she didn't call it that, she's referred to the fact that the purpose of this agreement was to reduce the sale price and also to replace the vendor and the vendee's interests, or the named vendor and the named vendee. So, and again, if we had an evidentiary hearing, all of this would come in, and the court would be very clear as to what is actually going on, which Dan was, I thought, very effective in describing. So,
Thank you. Mr. Stockram, anything else?
No, Your Honor, I believe you understand.
Okay. Well, it does appear in this matter, the court notes, obviously there's a dispute as to ownership, and that does appear to be very clear. So the court cannot say that there's a likelihood of success on the merits if there's a dispute on that. The court will hear an expedited evidentiary hearing. I'm going to have my staff get in touch with all three of you, and we'll set that up for next month in December. I will tell you, you're going to have to be flexible because I want it heard that quickly. And if in fact we cannot get everybody on board for a hearing date in December, then we'll just set a date and then everybody will have to appear at that particular time, because I want to get this resolved. But in this particular matter, the court cannot at this time determine that it's appropriate to grant a preliminary injunction, so I will not do so until such time as we have the evidentiary hearing. So we will be in touch with the three of you and set that up for a hearing. The hearing will be start at 8:30. And we'll do a full day hearing if we have to, and we'll have all of your documents. I would ask that the attorneys would at that hearing exchange all the documents with the other attorneys prior to that hearing so that they have those, and also provide paper copies to the court, because I'll want to have those rather than having to be online, et cetera. That's just more difficult to follow those. So we will be in touch with all of your offices probably tomorrow or the day after and try to get a date to have this heard, and then be ready to proceed on that day.
Your Honor, two questions.
Yes,
First question, will this be an in-person evidentiary hearing?
up to you. If you want to have it in person, we can have it in person. If you prefer to do it Zoom, we'll do it that way. It doesn't matter to the court.
I'll confer with brother counsel. Second, will the temporary restraining order be continued until the evidentiary
It will
hearing?
not. I'm not going to continue that until the evidentiary hearing. Mr. Monroe, I'll ask, because you were kind of more vocal on that, I'll ask that you would do an order stating that the court is not continuing that and would not enter a preliminary injunction at this time.
okay, I would be happy to do that. Judge, just one more question or request, and that would be that I'd like to be able to, before the hearing, to take the plaintiff Mo's deposition, if the court would order that.
Ms. Nazel, do you have any problem with the deposition before that hearing?
So long as I can take his client's deposition as well.
Okay, why don't you schedule the both of those? It looks like we're going to have to schedule the hearing later in December, but we'll get it in around the holidays. So let's see, we can make it work in your schedules, okay?
Okay, thank you.
Okay, thank you. You can put that in the order that those parties would submit to their depositions prior to the evidentiary hearing.
Judge, I was looking at your resume online, and looks like you and I went to Michigan State the same time.
Okay.
I was in Case, but
I was over in Acres, so we don't want to dredge up all how many years that's been, okay?
Well, I just thank God that we didn't have videos and smartphones back then, because we'd have some explaining to do today.
Not me. I was a model student, so I wouldn't have to explain that. Okay. Thanks. We'll be in touch with you.
Thanks,
Thank you.
Judge.
Okay. Have a good day.
You as well,
All
Your
right.
Honor. Thank you very much.
All right, thank you. Let's
Oh my goodness, that was him saying, hey, watch, we're in this little old boys club. I think you forgot about it, Missy. And the judge is like, no, we're not. I mean, we are, but we're not, you know. I think that's exactly what that conversation meant. Put what you think that conversation meant down in the comments, not the chat. The chat is lovely, but the comments are what YouTube Daddy loves. Guys, what a lovely evening. Thank you so much for being here. What do I do for Thanksgiving for my American friends? I will not be live on Thursday, but I will be live for a late night Friday night show, and we'll be live tomorrow. So we'll have lots of fun to watch. I hope that you have a wonderful rest of your evening. Remember that I love you, and I'm proud of you, and I will see you in the next video. Bye.
Ways down and ready to ride.